We've received the report from the state's expert evaluating our client for competency, and he agreed with both our expert and the independent court-appointed expert that he is not competent to stand trial at this time. So this morning the judge was informed. He lifted the previous gag order, and so that the state could start informing the families and letting them know what's going on, and now we'll move forward with incompetency procedures.
Something on this is competent to stand trial. This is separate from, some people may confuse it, this is not an insanity defense or anything like that, right?
This does not have anything to do with the insanity defense, although, I mean, obviously there's some overlapping issues, but the insanity defense is entirely about his state of mind at the time of the offense. Competency is about where he is today, now, on the eve of potential trial.
What happens now to your client?
The next step is to get him sent to a state psychiatric facility where he will be treated, and the goal of that treatment is to restore him to competency. When and if that's able to take place, once he is restored to competency, then the case moves forward towards trial.
So, all likelihood, the pending trial date,
January,
February, that's not going to happen.
The January, February trial dates are not going to, that will not be the trial.
Given what you know of the status of state hospitals to be able to treat the competency side of things, how long are we talking about before there's actually time to get your client in before something?
He has to wait for a bed to open up. That's true. We do not at this point know how long that might take, whether there might be some way to expedite that process. But all parties involved want to see this happen sooner rather than later.
Were you surprised at how quickly, because it was just the end of October, that the state made the request to get their own expert in after the court expert had already made a similar finding, your expert had made a similar finding? Were you surprised at how quickly this came around?
We were overjoyed at how quickly it happened, because all of the experts have made clear the need for him to get treatment. Just from an ethical standpoint, it's problematic to leave him untreated. So we are very grateful to the state, to the prosecutors, Jack Rohde, and his staff for making that happen so fast. It's been a long journey, and so we're glad that was able to happen rapidly.
What, if any, do you know, and Robert, you may be able to answer this too, the status of the federal case, how does that get affected by this right now? Do either of y'all know?
They can do, their case is totally separate, so they can still go forward with their competency, but since he's a juvenile, that's been sealed, so we have very limited information on that side.
So there's no communication between this defense team and the federal defense team? There's
communication, but there's a limit on what they're able to share with us about where things stand, because the case is sealed.
Up until the time he may find a bed to be able to stay in or anything like that, does he stay in the county jail? What happens?
He stays in the county jail, and there's some things that we can do one of the things that we'll be undertaking is some scans that he has not been willing to consent to up to this point, and the judge can order medication while he's waiting for that bed. So there are some steps we can take that will hopefully move the process along, but we're going to have to see how that all develops over the next week or two.
Said some scans that he's not been willing to take up until what are the?
Some brain scans and things. There's things that need to be ruled out that need to be done.
And so far he's just said, I don't want to do those.
I can't really comment on what exactly he said, but suffice to say we have not been able to get his consent.
But a judge could order that as part of this
Correct.
Process here. Correct. Obviously, a lot of reaction to this. Folks are waiting, everything else. Is there and I know this is all new, but have y'all talked to the DA about anything about a plea deal or anything like that?
The problem is once you get into where he is incompetent, then he can't make a plea, and so there's no real reason to have those conversations yet. Now, at such time as he might get restored to competency, then that might be a possibility.
So you couldn't even talk to his family about that. It still has to come from him.
He's
right?
The client.
Gotcha. Anything else in this that you think folks need to understand about this process? Because it does get a little convoluted for folks to understand.
Yeah. I think the important thing to understand is that 3 separate experts within their field have all come to their own conclusion and their own diagnosis, their own conclusion at this time that he's not competent. And so that would be, somebody appointed by the court, by the state, and someone from the defense team. And so at this time, 3 separate experts all agree that he is not competent. And so at this time, we want to just move forward to help him get to that point of competency and medical care. That way we can move forward with the case.
And we understand that there's going to be people that are frustrated over this, over how long the process takes. There's a reason that we have the laws and the rules that we do. This is the best system in the world, and it will work eventually. But sometimes we just have to be patient.
Is there a concern, though, even though you can't discuss a whole lot in the federal case, that the feds decide just to tell the state, y'all need to step aside, this is our case?
It's been a possibility since day one. It's always a possibility with federal involvement. To this point, that hasn't happened, and I can't predict the future on that.
You meet with the client as much as you can divulge what, and obviously this is coming from one side, but what, in meeting with him one-on-one, is he able to communicate? Is he able to maintain a conversation in any capacity?
Not a logical or sequential one, and that's really the best I can say. Is communication with him right now is extremely difficult in terms of goal-oriented communication, and it hasn't been possible. We're very hopeful that once he starts treatment, starts getting some of the things he needs, that will improve.
But you don't have any specific illness that he might have?
Not that I can disclose.
Okay, but you
For HIPAA reasons, I can't get into the substance of what the diagnoses might be. Suffice it to say, there are some.
Speaking of that, what portions of that do get entered in the court record for political review, or any of it at all? Just kind of the general finding, or
It's going to depend on if we do an agreed order. Probably if we have a hearing, it could be different. I doubt we're going to have that. So probably just the end result.
And that's an important part of the agreed order, that more likely the path to go is both sides say, okay, we're going to move to this next step, as you talked about.
Correct.
That won't be a hearing necessarily. Could be.
It could be.
But necessarily that it could be just both sides say, yes, judge, let's go ahead and go forward, get him in a state institution, and go from there. Correct?
Correct.
Anything else? Thanks.
As much as people are trying to say this is, the system's flawed and everything else, like Nick said, it's a great system. This isn't a problem with the system. This is just a mental health issue that we've got to work through. So it's not a win for anybody other than maybe mental health.
One last question, just not to tip your hand too much, but because of the way folks kind of look at this as kind of crossing streams and the like, do you plan on insanity defense at some point?
I can't speculate about that at this point.
But at this point, nothing's been filed that says we're looking at an insanity defense,
Correct. Correct.